Last July, Millicent Conway appeared before the Fulchester Magistrates' Court on a charge of arson. She pleaded not guilty. The case is now being heard before the Crown Court. The prosecution have alleged that the accused was seen at the scene of the fire, both just before and just after it was lit, and that in the interval, she deliberately lit it.
I call Norma Marilyn Bates.
Norma Marilyn Bates, please.
What is your religion?
Church of England.
Take the Bible in your right hand and read aloud the words on this card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
What is your full name, please?
Norma Marilyn Bates.
Your occupation, Miss Bates?
Sales lady. Cheese department in Rutherford's.
Where were you on the evening of the 17th of July of this year?
I was out near the old house, what they call Tipskill Manor. I was on my cycle, but the chain came off. I stopped and saw the old lady.
What time was this?
5 to 7.
Do you recognise in court the person that you saw?
It was her, the prisoner. She was standing there.
Where exactly was she standing?
Well, she was off the road. She was in all that rough light near the house.
How near to the house?
About from you to me.
What was she doing?
Nothing.
Nothing?
She was standing looking at the house.
Was there anyone else in the vicinity?
Pardon?
Did you see anyone else near the house?
I didn't see nobody. There wasn't nobody else there. She was all alone.
And on the road?
There wasn't nobody.
The road was completely deserted.
There was just me on the road with my cycle and her by the house.
Did you stop and speak to the accused?
I wondered about it, such an old lady all alone out there, but it had made me late, the chain coming off my cycle. She turned and looked at me, and I did wonder if I ought to stop. But she didn't seem to need no help. She just turned away again and looked at the house.
So you carried on pushing your bicycle?
Yes, sir.
Was the road still deserted?
There wasn't a soul to be seen.
Thank you, Miss Bates.
You said that the accused was standing in all the rough light near the house.
I imagine it was garden light once upon a time, but they'd let it go.
Can you describe how she was standing?
Pardon?
Well, did she, for example, have a walking stick?
She had 2 sticks.
How was she holding these 2 sticks?
She had one in each hand.
She was standing up straight, holding 2 sticks.
No, she was leaning on them, bent forwards like.
She was standing still, bent forward, supporting herself on 2 sticks. Other than the sticks, was she carrying anything?
Well, she couldn't really, could she? She didn't have no hand free.
She had no sort of handbag or hold-all.
Nothing.
Was there any baggage or anything visible on the ground near her?
Nothing I could see.
You didn't leave the road.
I was getting late, see. I had to get on.
Now, Miss Bates, the garden, or what was the garden of the house, is heavily overgrown.
A proper jungle.
Trees, thick bushes, dense undergrowth.
Yes, sir.
So there could in fact have been any number of people near the house whom you would not have been able to see.
There wasn't nobody about. She was all alone.
Well, we know that you saw nobody, Miss Bates, but in what you describe as a jungle, there could have been any number of people hiding.
Oh, well, yes, I see what you mean. There could have been people hiding.
And since you did not leave the road, you could not have seen round the other side of the house.
No.
Which is or was a large rambling building.
Yes, sir, a great barrack of a place.
Thank you, Miss Bates.
Constable Williams, your bicycle passed Tipskill Manor at 25 minutes past 7.
Yes, sir.
What did you see there?
Smoke, sir. There was smoke going up the side of the house. I dismounted, sir, ran towards it, and there was a fire started in a wooden shed up against the house.
Was any person nearby?
Yes, sir, the accused.
Well, where was the accused in relation to the fire?
Right there on the spot, about 6 feet away.
What was she doing?
Standing looking at the fire, staring at it.
Could you describe her appearance?
Yes, she was highly excited. She was waving a stick.
At what?
At the fire.
Was there anything else about her appearance?
Yes, her clothes were singed. She had on a woolly coat. There were sparks in the wool smouldering.
And the fire at this moment?
I was really taking hold. There was a bit of a breeze, see, and all of a sudden the flames came right out of a window above the shed where it started.
And what action did you take?
Well, I had to get away to a telephone, sir. I said, get back out of this, and I ran to my bike.
And then?
Well, it's about half a mile to the nearest house, Roundwood Farm. I used the telephone there for the fire brigade.
And having telephoned,
I went straight back to the house. It was well away, proper inferno. I looked round for the accused, saw her about 30 yards away from the house. I approached her, cautioned her, and said, what'd you go and do a thing like that for?
did the accused make any reply?
No, sir, she stood looking at me like I wasn't there, and then looked back to the fire.
Now, were her appearance and manner the same as when you first saw her?
No, she seemed calmer. She wasn't waving a stick like before. She seemed quite calm and collected. And I said, I hope you're pleased with what you've done.
Yes, you were, in effect, accusing her of having started the fire.
Well, it seemed obvious to me at the time, sir. I mean, no one else about, no one nearer than the farm.
Did the accused make a reply?
Yes, she said, I am pleased and proud with what I have done. I said, well, that's it then. It's a criminal offence. You'll have to come with me.
And did she reply to that?
No, she stood looking at me in the fire. I then tried to help her towards the road.
Did she require your help to get to the road?
No, she refused my help, sir. She said, I'm perfectly capable of crossing this garden.
And was she?
Yeah, it made it to the road quite brisk.
Without any assistance from you?
Didn't require my assistance, sir. At this juncture, the fire engines arrived.
What happened then, Constable?
Well, Mr. Hadfield came in his car, and when he could, he very kindly sent us down to the police station.
Yes, Mr. Hadfield, the municipal fire officer.
Yes, sir.
And when you arrived at the police station,
Made my report, and the accused was charged.
did she make a reply when charged?
Yes, she said, I'm completely innocent. I know the law.
Nothing else?
Nothing else at all.
Right. Now, could we go back, Constable Williams, to the moment when you first saw the smoke? You were bicycling along the road. Was there anyone else on the road?
No, the road was entirely deserted, sir, except for myself.
So how much of the road could you see from the point at which you stopped?
Well, about a mile behind, maybe 300 yards ahead.
And the road was empty.
Yes, sir.
What about the area around the house?
There was no one there, except for the accused.
Thank you, Constable.
Constable Williams, you have testified that the accused pointed with her stick,
Yes, sir.
with one of her two sticks.
Yes, sir.
And the other stick?
She was holding the other stick.
Leaning on it?
Yeah,
Bent forward?
somewhat bent.
It was supporting her.
I think it was, yeah.
She appeared to need the support of one stick while she waved with the other.
Yes, sir.
You say that she appeared excited,
Yes.
and she pointed with her stick at the fire.
Yes, sir.
In other words, she was pointing out the fire to you.
Well, I hardly needed it pointed out to me. I mean, not with it blazing like it was.
Nevertheless, she indicated to you with her stick that there was a fire.
Yes, sir.
And when she did so, she was excited.
She appeared to be in a state of high excitement, sir.
Can you elaborate on that?
Well, it was just high excitement.
The fire was now burning vigorously, and the accused was 6 feet away from it.
Yes.
She pointed it out to you with her stick in a state of high excitement.
Yes.
Did it not occur to you that she was trying to tell you to put it out?
Well, that's not how it struck me, sir.
Well, she wasn't trying to hide the fire from you,
No.
nor trying to hide herself.
No, sir.
On the contrary, she was urgently pointing out the fire to you.
Yes, sir.
In the flames that were now roaring, there must have been burning fragments being blown about.
Not that I saw.
Well, there may have been some.
I don't recall seeing burning fragments being blown about, sir.
Can you swear that there were no fragments?
Well, I expect there may have been a few.
And the accused was quite close enough to the fire for burning fragments, if any, to have lodged in her clothes,
Yes, sir.
which would account for the singeing and smouldering that you saw.
Yes, could.
If the accused had herself tried to put the fire out, that would also account for the singeing of her clothes.
Yes, it would.
Did it not cross your mind that the accused was in the state of shocked excitement which you describe and with singed clothes because she herself had tried to put the fire out?
That's not how it struck me, sir.
Does it not strike you now?
No.
My lord, my learned friend is asking the witness to speculate about events which he did not see.
Yes, Mr. Collier, please confine your questions to what the witness saw and did.
Very well, my lord. The witness has testified as to his assumption that the accused started the fire, which was also speculation about an event he did not see.
He has testified as to what he said and why he said it.
Very well, my lord. Now, Constable Williams, you said to the accused, what did you go and do a thing like that for? having jumped to the conclusion that the accused had started the fire?
That was the only conclusion to come to.
Because she appeared to be alone?
She was alone, sir.
How can you swear that she was alone?
Well, no one else was visible in the vicinity of the house.
You didn't go round the house,
No, sir.
nor into it.
Not likely.
Did you thoroughly explore the dense shrubbery and undergrowth near the house?
No, sir.
The undergrowth is dense.
Yes, quite a tangle of bushes, sir.
Large enough and thick enough to have concealed a person or many persons?
I suppose so.
Well, without asking you to speculate, Constable, but only describe the shrubbery, was it of a kind that could have concealed, say, half a dozen small boys in hiding?
Well, yes, sir, there could have been small boys. I'm sure there wasn't.
How are you sure? Constable, you cannot be sure. There wasn't an army of small boys in the bushes or around the other side of the house.
There could have been boys.
Thank you. Now, the accused, when you saw her, was leaning on one stick and waving with the other.
Yes, sir.
Since she held a stick in each hand, she was carrying nothing else.
No.
No handbag. She was carrying nothing.
No, sir.
Nor was there anything nearby on the ground.
No, sir, not that I saw.
No package, carrier bag, nothing.
No, sir.
I see. So when the accused crossed the rough ground to the road, she did so without your assistance.
Yes, sir.
But you offered your assistance.
Yes, sir.
Why?
Well, she's a very elderly woman. An old lady. I thought you'd be glad of a hand.
Because of her age and frailty and difficulty in walking?
Yes, sir.
When she was standing still, she was able to gesture with one stick while leaning on the other. But as soon as she made any attempt to walk,
She used both her sticks.
with each step that she took, when she crossed the rough ground to the road, she required the support of both sticks.
Yes, sir.
You said to the accused, "I hope you're pleased with what you've done,"
Yes, I've informed the opinion that she was responsible for the fire.
having jumped to that conclusion when you first saw the accused close to the fire.
Yes, sir.
And you jumped to that conclusion on the basis of your observation. First, that the accused was close to the fire. Second, that no one else was visible close to the fire. Third, that her clothing was singed by the fire. And fourth, that she appeared to be excited about the fire.
Yes.
Because of these things, and no others, you concluded that she had started the fire. But you made no attempt to take her into custody for the serious crime which you thought she had just committed.
I did take her into custody.
At the time when you first saw the accused and before you went away to telephone, all you did was to warn her to get away to a place of safety.
Yes, sir.
You took no action at all to secure the person of this, to you, obvious criminal.
Well, the other seemed more urgent. Getting a fire engine seemed the urgent thing.
If you'd found a small boy with a box of matches in his hand, surely you would have collared him.
Yes, before he ran away.
If he ran away, he would have escaped the consequences of his crime.
Yes, sir.
But you made no immediate attempt to arrest the accused because it did not cross your mind that she would try and run away and hide.
Oh, I didn't think she could run very far.
You mean that she can only walk slowly and with difficulty and with the aid of two sticks?
Yes, sir.
And in any case, she showed no signs of even wishing to escape.
No?
You thought you'd be quite safe in leaving her, that when you got back from telephoning, she would still be there.
I suppose I did.
And in the event, when you did get back, she had made no attempt to escape, but was standing in full view, watching the fire.
Yes.
Is that what you'd expect of someone who's just committed a crime?
Well, I don't think the accused is like an ordinary criminal, sir.
I agree with you, Constable. And I don't think, do you, that in making no attempt to hide either the fire or herself, she was acting like any kind of criminal, ordinary or not, like a person who has committed any kind of crime.
It's not like a normal delinquent, no.
Did you caution her? She appears to have no recollection of it.
I did, sir.
Well, you said, "Look what you've done." And when she made no reply, you said, "I hope you're pleased with what you've done." To which she replied, "Yes, I am pleased and proud with what I've done." How did you interpret that reply? What did you think she meant?
Well, I took it as an admission, sir.
Why?
Well, it's obvious.
Was it? Suppose the accused had herself tried and failed to put the fire out. Might she not at her age be proud of that? Is that not an equally possible solution?
My lord, my learned friend is now asking the witness to speculate about the mental workings of another person.
Yes, Mr. Colley, the accused can tell us what she meant when she herself gives evidence. It is not a subject about which this witness can testify.
As your lordship pleases. I'm suggesting that the witness jumped to unwarrantable conclusions as to the meaning of the words the accused employed and as to the reasons for her visible excitement.
Yes, I take your point, Mr. Collier, but you must confine your question to matters about which this witness can testify.
Yes, my lord. I have no further questions.
Mr. Hadfield, as part of your duties, you made an inspection of Tipskill Manor on the morning after the fire.
I did, sir.
What was the result of your investigations?
I concluded deliberate incendiarism. The premises were not on the main electricity supply. The generator that had supplied electricity to the house was inoperative and had apparently not been in use for many years. There were no traces of damp straw or any other decomposing material that could have caused spontaneous combustion. The sun had been, at the relevant time the previous evening, neither high enough nor bright enough to have started a fire by an accidental burning glass. The wooden shed in which the combustion had started had in any case no glass in the windows.
Apart from finding no reason to suspect spontaneous combustion, did you find any reason to suggest deliberate fire-raising?
Yes, sir. An empty half-gallon paraffin can.
May the witness be shown Exhibit 1, please? Is that the can?
Yes, sir. It was lying about 7 feet from the corner of the lean-to shed, concealed in a clump of briars. Paint of the label was somewhat scorched, but substantially legible.
And you think it probable, Mr. Hadfield, that the fire was started with paraffin which was poured over the lean-to shed from that can, and that the can itself was then concealed in the brambles which were themselves partly burnt?
Oh, I should think it more than probable. Everything I saw was consistent with the fire having been started as you describe.
I'm obliged, Mr. Hadfield.
Now, Mr. Hadfield, the can appears to have no date.
No, sir.
It's made of a non-corrosive material, rusts nor wets.
That is so, yes.
So the can could have been in the brambles for a week, or a month, or even a year.
Not a year, sir. The brambles would have grown over it completely.
Well, just so. Let's say the can could have been in the brambles for a week.
I suppose it is possible, sir. Strictly speaking, one lives might have been a week before.
So that in linking the can to the fire, you are reaching a conclusion which, while on the face of it obvious, is in fact speculative.
At least it's a more convincing speculation that someone went all that way to an empty house to hide an empty can in some brambles.
Well, returning from speculation, Mr. Hadfield, you say that the damage was consistent with the fire having been started with paraffin.
And inconsistent with anything else. That fire didn't start on its own.
You mean that you could find no reason for it having started on its own?
None.
That's not the same thing, Mr. Hadfield.
I give it as my opinion, sir, formed not lightly, that no accident without human agency could have started a fire in a premises without electricity, without material that could have caused spontaneous combustion, and without bright sunlight. I've never seen a clearer case of arson.
You're careful to use the word opinion.
Yes, sir, and I'm careful with that opinion.
Well then, in your opinion, could a small amount of petrol splashed on the shed have been used to start the fire?
Certainly, sir. But what I found was a paraffin can.
But petrol or any other inflammable spirit could have been used.
Yes, sir.
And a match struck by anybody who happened to be there with a matchbox.
With respect, sir, I'm not asked to form an opinion about who struck the match, but I am qualified to give an opinion that a match was struck.
Thank you, Mr. Hadfield.
I call Albert Morton.
Albert Morton, please.
What is your religion?
Church of England.
Take the Bible in your right hand and read aloud the words on this card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Mr. Morton, you are the owner of Morton's Home Stores of Glenview Road, Fulchester.
Yes, sir.
Have you seen the accused before?
Yes, sir. She's a regular customer. Comes in twice a week or thereabouts.
And has been doing so for how long?
Oh, ever so long. As far back as I can remember. Oh, since I was demobbed and took over the shop from my dad.
And what did the accused buy from you?
Grocery, it's the usual kind of order, sir.
Which you delivered?
The last few years I've been delivering, sir, yes. On account of Miss Conway getting on, you know. Not so young as she was.
Did you ever buy paraffin from you?
Not once in all them years, sir. Then suddenly she wants paraffin. Half a gallon can. Paraffin, I says, Miss Conway. Paraffin, she says, quite bluntly, not inviting questions.
Can you remember the date?
Second week in July, sir.
Were you surprised by this order?
Well, it did seem a bit odd, sir. I mean, here we are in midsummer and quite a hot spell.
What brand of paraffin did you deliver to Miss Conway?
Warm Glow, sir. That's the one I carry.
Was it in a container like this?
Yes, sir. That could be the very one.
Now, how much paraffin has the accused bought from you since?
None, sir.
None?
No, sir.
Just the single, isolated can in July?
Yes, sir.
Thank you, Mr. Morton.
Thank you.
Mr. Morton, do you know of other grocers who sell paraffin?
Oh, quite a number, ain't it, sir?
Ironmongers and garages also?
Well, they've all got part of the trade, sir.
In fact, there are hundreds of such businesses in Fulchester,
Quite, yeah, must be hundreds, sir.
many of which carry this same brand.
I should imagine so, yes.
So you could not possibly identify this can as one which you sold,
No, sir. But it is like what I sell.
and like what many others sell. The design on the can hasn't changed recently,
Not that I can recall, sir. I think they've had this print for a very long time.
so you could not put a date on this can.
Oh, impossible, sir.
You or any other retailer might have sold it to anybody at any time over many years.
Yes, sir.
Thank you, Mr. Morton.
Thanks.
I want to be quite sure that we understand the witness on one point, my lord.
Very well.
Mr. Morton, Miss Conway has been buying all her groceries from you for over 30 years.
Oh, yes, sir. Takes me back to the ration book day, sir.
And in all that time, she has never bought paraffin.
Never.
Thank you, Mr. Morton.
Thanks.
Does your lordship have any questions?
No, thank you, Mr. Morton.
That concludes the case of the prosecution, my lord.
It appears to be slightly incomplete, Mr. O'Connor.
My lord?
I refer to evidence as to ownership of the property which the accused is alleged to have destroyed.
Yes, well, there has been a difficulty, my lord. The owner of the property is believed to be in Australia. It has not been possible to make contact with his solicitors or with himself, and the whereabouts of the deed is unknown. A great number of property deeds were destroyed in the war when the offices of solicitors and insurance companies were damaged due to bombing. It seems likely that this deed was amongst those. However, the defendant's solicitor have been kind enough to indicate to me that no claim is made that the property belongs to their client.
Is that so, Mr. Collier?
Indeed, my lord. My client does not assert any title to the property.
Very well.
My lord, I call Millicent Conway.
The case of the Queen against Conway will be resumed tomorrow in the Crown Court.